23 minutes to the top of the hour, 10. There are petitions flying around left, right, center. So far, we know of 3 of those petitions. Certainly once the Chief Justice of the Republic of Ghana out, we'll be exploring the constitutional angle. We'll also be looking at the processes and the timelines. The former Attorney General, Godfred Yeboah-Dame, is representing a Vincent Asafua, who disagrees with the petitioners, and the present Attorney General, Dr. Dominic Ayene, who also is a lawyer for the state, the senior most member of the bar, the most important member of the bar, if you will, as the President of the Republic and the Republic of Ghana as his clients. So 2 Attorney Generals, 1 former, 1 present. And we know what their position has been. But let's take a look at the timelines when this matter began. And I'm sure you've been watching closely the timelines, what we have. When did this petition and matters arising come? Let's talk about it.
All right, at least let me begin from the point at which the president referred the petitions to the Council of State, and then we can take a look
at... That's a matter of constitution.
Exactly. Right. Then we can take a look at the constitution. So on the 25th of March, 2025, the president referred the petitions to the Council of State. 2 days after, on the 27th of March, a suit was filed challenging the president's referral of these petitions to the Council of State.
Right.
Now, again, the Chief Justice, Her Ladyship Gertrude Tokonu, wrote to the president asking for copies of the petition. She wanted to see what these petitions had to say.
Which is supposed to be the case, by the way, that she's supposed to be giving a fair hearing. She needs to see the petition, and that must be done. So that's what done on the 27th of March.
Now, on the 28th of March... The President Mahama, wrote to the CJ, giving her 10 days to submit responses. You recall that she actually asked for 7.
Right.
And got an additional 3 days to add on to 10. That, to make it 10 days. Now, on the 9th of April, 2025, the Supreme Court was to hear 2 cases challenging the suits. One by MP Oltafo.
That's right. Who is himself a lawyer.
That's right.
Okay.
Represented by former AG.
Former Attorney General Godfred Yeboah-Dame.
That's right. Now, on that same day, many of you were waiting. Others were in a different jurisdiction, but we here on home, so we were waiting eagerly to see what will happen.
The internet puts us together.
I see. The Supreme Court, however, adjourned indefinitely the hearing of the injunction applications.
Right.
So many questions left unanswered. Now, the 16th of April, 2025, that's just yesterday, we now know the Supreme Court adjourned the injunction suits to May 6th due to unavoidable reasons. May 6th is the date now.
I see. So the former Attorney General of the Republic of Ghana, Godfred Yeboah-Dame, who's representing Vincent Asafua, he spoke to the press after the hearing at the Supreme Court. Here's what he had to say to the public.
There's an application for temporary injunction pending. So why would anybody proceed? I'll find it quite interesting, quite odd. The highest of a disregarding rule of law.
So as far as you are concerned, you expect the president to halt the constitution of the Council of State while this is pending?
It's not my expectation. It's the expectation of the law. The law expects that such regard for due process be observed. And so it will be actually a confirmation of their disregard for the rule of law. And I think that you see the affidavit filed by the Attorney General.
I mean, there are those who have made reference to the fact that in that affidavit, he makes the point that there's no law that requires a fair hearing to be given to the Chief Justice. And there are some who are also saying that even under the previous government, the president gave a hearing after he had referred the matter to the Council of State already.
I would say that the Lord has a fine way of exposing the hearts and desires of men. The Lord has an interesting way of exposing the hearts, the true desires of men. And indeed, it's been evidence in the affidavit filed by the Attorney General. They did not intend to accord any right of hearing to the Chief Justice until the matter was filed. They indicated it in the affidavit. So it's quite clear. I'll leave it at that. The merit determined by the court will argue in court. Thank you.
So that was the former Attorney General, Godfrey Adami. Certainly, he believes that because there's an injunction in court, he expects that the processes will halt. The current Attorney General holds a different view. What's his view? Listen.
The injunction application.
No, it's not. The decision whether or not to hear the case is not mine to make. All right. And the reason why we were absent at the last adjourn date was because we organized a training far ahead of the date that was given to us by the court. And the training was for all state attorneys, all right, by the ECOWAS Court of Justice. So they were being trained on the procedures and rules of the ECOWAS Court of Justice. And because of that, I was deeply involved in the training. My deputy was deeply involved in the training. The ECOWAS delegation that was doing the training was here in Accra. And we just asked for a date. Lawyers ask for this all the time when they are constrained and cannot be available in court. So for you to interpret that to mean that we are not willing, to go along with this process is totally unacceptable.
That's Dr. Dominic Ayene. He is the current Chief Justice. And then Global Influence Analytics, based on the back and forth that we're experiencing, conducted a research, as they are known for, and the question they put to the public was, do you support the attempt to remove the Chief Justice? Crosby, what did they find? Global Info Analytics.
So, I nearly said 60. Johnny, when that question were asked, of the number of people they asked this question to, if you're doing the percentages out of 100, 52% of them, that's 2% more than half of 50. They said they support the attempt to remove the Chief Justice.
Right.
Those who oppose it are only 20% of the number. But there are 18% who are indifferent. They are neutral. Whether you remove her or not remove her is really none of their business, they say. And 10% of them, they say they don't have an opinion on the matter. That's according to the research by Global.
So let's go back to that. Let's see those who are in support. That's more than 50%.
Yes, more than half
of the population or sample size that Musa Danquest Global Influence Analytics spoke to, say they support the removal of the Chief Justice.
Exactly.
20% oppose it, 18% are neutral, and then 10% have no opinion. But let's look at the regional distribution, the breakdown. They spoke in the Ashanti region, Greater Accra region, Volta region, Western North region, right? What do the figures say?
Let's start from the Western North region. And I don't know why.
You use the microphone for me.
I don't know why the numbers are looking like this though. But for the Western North region, 82% of respondents who answered this question by Global Info Analytics, they support the attempt to remove the Chief Justice. And then we go to the Volta region, 76% do. Now, the Greater Accra region, 58%. Then the Ashanti region, I don't know whether this is expected or this is an outlier. They only 37% of the respondents agree to or support the attempt to remove the Chief Justice. So just 4 regions here, and this is the breakdown: Western North, Volta region, Greater Accra, and Ashanti region.
Let's look at the party affiliations of these individuals who participated in this research. What do we know?
For party affiliation, Johnny, let's start with the NPP first. So for the NPP, we're looking at 16% of NPP supporters agreeing to the attempt to remove the Chief Justice.
Right.
Now, 46% of them, they oppose it. And then we're looking at some 26 who are neutral. They don't care wherever it goes.
Right.
But 13% they don't have an opinion. So 16% support, 46% oppose it.
16% of NPP affiliated party people say they support that the Chief Justice will go.
Exactly.
But 46% of the sample size that we had who said they are NPP people say that no, we don't want the Chief Justice to go. What about the NDC?
The NDC, now this, I don't know whether it should be surprising too or not. 83% of NDC supporters who Global Info Analytics spoke with support the attempt.
That's in the roof.
Exactly. That's close to 100. The roof. Almost 100.
83%.
Yes, that's an A.
If you compare that to the MPP 16% who wants the Chief Justice gone. It's quite, and you know, even though we know that some persons may want to fuel this removal of Chief Justice with political undertones, it has to be based on the law.
Exactly.
And we'll get to the law shortly.
Yes.
Now, 83% NDC people want the Chief Justice to go. How many oppose that of the NDC lock?
Johnny, this is 3%. The
3%.
number, just 3%.
Say the Chief Justice should
stay.
stay. Okay. What are the numbers for neutral?
For neutral and those who
have
have
no
an
opinion?
opinion, just 7% of them. So they are sharing the
7% apiece.
Yes, 7% apiece.
Okay. Now we will look at some other detail of this, and we want you to pay particular attention to Article 146 of the 1992 Constitution. Helen, this is what the lawyers have been bombarding us with, but we want our listeners to also have a fair view of what it means. What does Article 146 say?
All right, and that one is centered around the removal of justices of superior courts and chairman of regional tribunals. Article 146(1). Article 146.
And just to mention that we no longer have regional tribunals.
Okay.
So,
although the NDCA was hinting at it's maybe making a comeback,
well,
it's not in the system. Now, a justice of the superior court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior or incompetence, or on ground of inability to perform the functions of his or her office arising from infirmity of body or mind. 2, a justice of the superior court of judicature or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article.
Great. Article Clause 3.
Clause 3. If the president receives a petition for the removal of a justice of a superior court,
right.
That's right, other than the Chief Justice, or for the removal of the chairman of a regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case.
So if it is not the Chief Justice, the matter will be referred to the Chief Justice. But in this particular instance, it is the Chief Justice. What does the law say, Article 146?
Now, where the petition is for the removal of the Chief Justice, the president shall, acting in...
Which means it is mandatory.
Mandatory.
Right. It's not he shall.
Depending on which lawyer you talk to, but that's neither here nor there.
No, but we all know. I mean, this basic, what I learned in media law.
That's what I thought.
No, that's what I learned in school.
Same.
I got an A for media. So,
but in the last few weeks, I've heard different interpretations of shall.
Of the same shall.
Of the same shall. So don't be too surprised if you hear it interpreted in a different way.
Depending on who you speak to.
Please, don't be surprised.
Right. So, where the petition is for the removal of
the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and the other 3 and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers.
I see.
Now, 7, the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. Now, 8, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other experts of his choice. The President shall, in each case...
Clause 9.
Yes, Clause 9. The President shall, in each case, act in accordance with the recommendations of the committee.
Interesting.
Now, 10, where a petition has been referred to a committee under this article, the President may, A, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice.
Okay.
B, in the case of any other justice of a superior court or of a chairman of a regional tribunal, acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal. Now, Clause 11, the President may at any time revoke a suspension under this article.
Okay, so there are two things that we know has not happened in all the processes. We know that the petitions have been written, they've been transmitted to the president. The president has subsequently transmitted it to the Chief Justice to get a response, right? We also do know that the transmission has happened to the Council of State, but there's also two cases in court challenging that process be halted. There's an injunction on it. The Attorney General is in court fighting. The Supreme Court says we will reconvene on the 6th of May. We know that has happened. What we do know has not happened is that there has not been a committee that has been formed, all right? And we also do know that once the committee has not been formed, a suspension may not happen, all right, per what we have read here.
Right.
We will go on to the phone lines, but first, quickly, let's listen to the minority leader, Alexander Kwamina Afenyo-Marking. He made a point yesterday at the press conference. Listen to him.
We are also concerned about an attempt by certain individuals in government to push for the removal of the Chief Justice. The judiciary should not be seen as part of the partisan political system in our country. All we need is to have an impartial judiciary to dispense justice. What is happening is unacceptable, and it's clear that the NDC government wants to infiltrate the judiciary and make it partisan. But my advice to all judges in the country: stand together. Let not somebody create an impression of one of you and think that by dislodging one of you, you will be the next. The next day, you would also be the next. So judges in the country must stand together. The judiciary must stand as one body and make a full statement to condemn this act. The Ghana Bar Association must also stand for the judiciary. Civil society organizations must stand for the judiciary. All these flimsy, pedestrian excuses, looking at what is out there, I mean, you wonder whether these are real, grounds for the removal of a Chief Justice. And, well, this is NDC for you. Some hardliners are still pushing for it. So I would plead with President Mahama. I see him as a statesman because this is his last and final term. So he's no more part of the mainstream politics. He should be looking at leaving a legacy. The hardliners in NDC should be kept on the fringes. They shouldn't be allowed into the center to disrupt the governance process because they would want to remove everybody.
That's Alexander Kwamina Afenyo-Marking. He's the minority leader in Parliament. Osman Alassan is a private legal practitioner joining us now. Counsel, good morning. Thank you for your time.
Good morning, and good morning to your listeners.
What could the president be doing wrongly and be going opposite the law that be having incensed the minority leader, first of all, and secondly, for him to now calm down and appeal to the president to be a statesman and not allow his party people to push him to do what the petitioners are asking for?
Well, I don't think the minority leaders' pronouncements were motivated by a wrong done by the president. For me, if you ask my opinion, I think that statement is purely political.
Sunrise on 3FM, the best in the morning.
And it surprises me that the minority leader is making those statements. He might not realize, but I think those statements are actually.
Counsel, your line is not clear. It's breaking. You might want to reposition yourself so we can get.
Okay.
Oh, sorry about that. We lost. Counsel, please fetch him back on the phone line so we can quickly talk to him. I want to get his opinion. And Helen, he says that this is purely political, the statement from the minority leader. Nothing to do with something being done contrary to the law. And that has been the position of those on the side of the NPP literally that, well, this is witch hunting, this looks politically motivated, it's wrong, we must not do it, we must protect the Chief Justice. I'll come to you. Counsel, welcome back.
Thank you very much.
Great. So you were saying that the comments made by the minority leader are politically motivated, and it was not because the president was doing anything wrong by transmitting the petition as he should, as by law.
Yes, because as we all know, the procedure in Article 146 is clear, and the Supreme Court has brought an addition, which is also clear and express in the Supreme Court decision in Adjourns and Attorney General. And what was that addition? The addition is that he should determine prima facie case before initiating the proceedings for the removal of the Chief Justice, or before setting up a committee to now investigate it further. And that's exactly what the president has done. And so for me, it is not anything that the president has done wrong per se, but I think it is a partisan political statement, because they think that the Chief Justice removal process is being initiated because she was appointed by the previous government.
Right.
Yes, that's how I see it. But those remarks and those statements from no less a person than the minority leader are really dangerous, because I hear him calling on the judiciary and the Ghana Bar Association to stand up to the process. And that surprises me, because this is a lawmaker, and the least we expect from every lawmaker is to respect the Constitution.
Right.
Now, if you say that judges must come together and resist the removal of a Chief Justice, what you are trying to say, first of all, is that you know the basis for the removal, and you think the basis is not grievous enough to grant a removal of the Chief Justice. Meanwhile, constitutionally, this process must be confidential. That's number one.
Right.
Number two, is he saying that we should take out Article 146 from the Constitution, or he thinks that there must be, once the Constitution contemplates and prescribes a way for removal of Chief Justice, there must be at one point in the removal of Chief Justice, but he thinks that this particular process is not one of those instances. And if you say judges should stand up, now, why are they standing up? Are they standing up to Article 146, or they are standing up to or against the grounds for which the Chief Justice is being removed, or the Chief Justice removal process is being triggered? Because we should assume that as senior marking and the judiciary or the judges calling upon are not aware of the content of the petitions.
Right.
And so if you are not aware of the content of the petitions, how would you know whether the grounds for the removal are grievous or not?
I see.
So if you make such a call, it is really, really dangerous. It's like you are calling for an overthrow of a constitutional provision, and which is Article 146. Article 146 doesn't particularize any Chief Justice. It just makes provisions for the removal of a Chief Justice. It could be any Chief Justice. And so it would be on the grounds for which the Chief Justice would be removed. And if you are not aware of the grounds, even if you are aware of the grounds, we should practice. The Constitution gives that prerogative of determining or establishing the case against the justice.
I see.
And we should respect those authorities. Look, if you check look at the Council of State right now, you will find that you have a former attorney on there.
Right.
You have a former Chief Justice in there.
Right.
You have a former Speaker of Parliament in
Right.
there.
Right.
Look, these people are not just, they have had experience of public service.
Right.
And particularly with respect to the former Chief Justice, who is now on the Council of State.
Right.
Do you know that she was who determined the prima facie case for the removal of Charlotte Osei?
That's correct.
Yes. So she will not be or not be ignorant. She will be the least ignorant about what prima facie case is in the removal of a superior court judge or the Chief Justice. And so we should track that when they establish prima facie case, it is a prima facie. And if they say there's no prima facie case, then we leave it at that point. It is a constitutional process. And now that those remarks and statements and instigations, also presupposes that he's being prejudicial. He has some knowledge that the process is being initiated or motivated by the government itself, and he is aware that there is a predetermined conclusion that the Chief Justice will be removed, and so they should stand against it. I mean, you don't make statements like that, especially as a minority leader.
Great. Now,
yes.
Final question to you is that would you be surprised if a prima facie case comes up, a committee is formed, and the Chief Justice is suspended? That would mean one or two things. Either she goes or she survives and stays. Would you be surprised if any of the two happens?
I don't have the surprise or otherwise. I can only be surprised or otherwise if I am aware of the ground in the petitions. Now, if I am aware of the grounds in the petitions and then the committee established by the prima facie case is established by looking at those allegations and perhaps the evidence given, then I will say, I am surprised that this has happened. I am not surprised that it has happened. But here is the case. I have no clue about the grounds that are contained in the petition. And I have no clue the evidence that is before the President for the establishment of the prima facie case. And so I can't be surprised or otherwise. But generally, I think I said this previously, that public perception about the Chief Justice and the Supreme Court itself is not a favorable one.
Right.
And so based on that, because there are statistics, I think someone has published some statistics about those who want hair removed and all that. So if you on those statistics, I will not be surprised if the prima facie case is established.
Great.
Which will mean that the grounds.
Thank you, Counsel. Osman Alassane, we're grateful that you joined us this morning. Thank you so much indeed. Great. Let's now do some birthdays before we check out of the studio, shall we?